Okay, it is October 18th, 2023, and I'm very pleased to be here today. I'm Phil Hirschhorn. I'm here with my colleague, Keith Jones, and we're here to give you Panitch Training Academy session number 20. So it's our 20th anniversary, or at least 20th episode. We are here to kind of give you an introduction to patent litigation, as is the title of the slide that you see. Our purpose here is not to teach you patent litigation, but to give you an introduction, to give you a sense of what patent litigation is all about. This is also a CLE production, so we're going to ask you a couple of things. Number one, if you have any questions for us at any time, please use the chat or the Q&A section for any questions. We will check it frequently. We will try to address your questions in as timely a fashion as possible. For those seeking CLE, we will have two polls popping up around the 20-minute mark and the 40-minute mark. And you should answer if you require Delaware, Pennsylvania, Georgia, or Virginia CLE, or a certificate of attendance that can be used in another jurisdiction. We will also be sending you a Survey Monkey. And the Survey Monkey will ask for feedback on our performance, our presentation, things that you would like to see in the future, and we will do our best to try and meet up with your requests. We are here for you, and that's one of the reasons we are given this presentation. And with that, I think that I've done my introductions, and I thank you all for being here today. I am one of the co-heads of patent litigation at Panitch, Schwartzy, Bellosario, and Nadell. Keith has been tasked with having to support me all over the place, and I have to support him all over the place in patent litigation and in trade secret litigation and other litigations as well. And one of the things we want to bring to you is kind of an overview of what we're going to do here today. And so when we move to slide one, hopefully we can move to slide one. There we go. This is our session overview. We basically have 11 sections that we will address. We'll try to address them relatively promptly. We have 1 hour, so we have to, Keith will tell you that I speak too much. I will try not to speak too much today. We're going to do an overview of the U.S. patent litigation, just a very brief overview, where it comes from, some of the jurisdiction and venue considerations, the complaints, defenses, and preliminary motions is our third section. Interplay with the Patent Trial and Appeal Board, or the PTAB proceedings, which is hugely important in patent litigation today. Discovery, so the thing, if you are watching this from overseas, you know the hatred you have for American discovery. We will talk a little bit about that. We will talk about claim construction, the construction of the claims at the end of the patent. That is all important for all of us as we try and understand what our patents mean, whether we are on the right side or the wrong side, if we happen to be somebody with a product or a process in the field. We will talk about experts. We will talk about trial and hearings and relief. We'll talk about the post-trial papers that are possible after a trial or even during a trial, and appeals. We'll give you some statistics, and we'll talk about fees and costs. There is no fee for this presentation. Let me go to the next slide. Okay, I'll be handling section one. Overview of U.S. patent litigation. It is typically really now a two-forum activity. We have the U.S. district courts at the top. There is a federal question for U.S. patent litigation, so any U.S. patent litigation can be brought in the federal court system. That having been said, there has to be either patent infringement, so you have to actually meet the statutory requirement once you get into court in order to stay in court, in order to create a question of fact that can eventually go to a jury or hopefully summary judgment if you are the patent holder and you don't have to spend the cost for trial. You could also be there on a declaratory judgment action, which would typically be a threat from the patent owner to an alleged infringer to create really an action for either non-infringement or invalidity or some other DJ, but those are typically the two you would see. I said it's really to forum activity today. And I'm going to skip to the third issue, is the Patent and Trademark Office and post-grant proceedings. We'll talk more about that. But effectively, every action has the possibility today of having a parallel proceeding in the Patent and Trademark Office at the PTAB through either the post-grant proceedings, the post-grant review, the inter partes review, or some other review proceedings. We also have patent infringement actions in the International Trade Commission, where you have an action for what's called an exclusion order. It's not a damages case. Then you have non-judicial fora, such as taking things to arbitration or having some private rights of action that are basically hosted by entities like Amazon that really relate to their market and their marketplace. And with that, Keith.
Thanks, Phil. The bulk of U.S. patent litigation happens in court rather than the ITC or in these Amazon type forums. And so before you go to court and file anything, first question you have to answer is, what court are you going to go to? By statute, federal courts have the subject matter jurisdiction for any case relating to a federal statute. The U.S. Patent Act is a federal statute, and so any court case involving a patent infringement has to happen in federal court, not state court. And by extension, if you have a parallel, say, breach of non-disclosure agreement or some other state law type claim, federal courts can hear that too, as long as it arises from the same or similar set of facts. And so once you've determined that you're in federal court, you have to determine which federal court. And so the big question is venue. There's a special venue statute for patent infringement cases, and it says that patent infringement cases can be brought in the judicial district either where the defendant resides or where the defendant has committed acts of infringement and has a regular and established place of business. This actually came to a head about 6 years ago. The Supreme Court heard a case on patent venue. The Federal Circuit had previously took a pretty broad definition of where a defendant resides, and so it was very easy to find venue pretty much in any jurisdiction that the alleged infringer had a place of business, sold to, advertised in, you name it. The Supreme Court said that's not how it works. They said that based on their prior precedent, which the Federal Circuit had effectively ignored, a corporation resides in the district where it's incorporated and nowhere else. And so this put a much narrower interpretation on where you can file a patent infringement case. And so you either have to check the articles of incorporation, find out where they're incorporated. Often that's Delaware. And we see a lot of patent infringement cases in the District of Delaware. Or you have to find essentially where the defendant has a brick and mortar store, which would be a regular and established place of business, or a brick and mortar office. And from there, they have also committed acts of infringement. And the other factor is personal jurisdiction. It's pretty much coextensive with venue. If you meet venue, then you're almost certainly going to meet personal jurisdiction. And so we don't really see a lot of challenges on personal jurisdiction unless venue is also a problem. And so the plaintiff is the party who chooses the forum, and usually that's the patent owner. And there's a lot of different considerations you can have for picking your forum if the defendant can be sued in more than one. Sometimes you can pick courts for their speed. The Western District of Texas is currently the one that is sort of the hot spot to get to trial really fast. It used to be the Eastern District of Virginia and I believe the Western District of Wisconsin were known as rocket dockets. That has petered out in recent years. So that's a thing that changes every so often. We try to keep an eye on that. Other courts are known for being sort of friendly to plaintiffs. The juries give large awards. The judges tend to be a little bit friendlier to, on summary judgment motions or claim construction. The Eastern and Western districts of Texas are big ones for that right now. On the flip side, some of them are known as being a little bit more pro-defendant. The Northern District of California is one of those. Not so coincidentally, that's often the site of where all the tech companies are based. And I think that the courts may have a little bit of an implicit bias to make sure that that business isn't hurt too much. Another consideration you can take into account is whether the jurisdiction has patent rules. And these are often rules for how to structure your scheduling order, how, when and how you have to serve infringement contentions and invalidity contentions, and all sorts of things that weigh on a patent case. The District of New Jersey has a great set. The District of Delaware doesn't have a set per se, but the judges all sort of have an unwritten understanding of how it works, and they all have standard scheduling orders that are very similar to each other, and they account for patent cases very well. So, these are the things as a plaintiff that you weigh, and you're just bounded by the jurisdiction and venue requirements. As Phil mentioned, you can also file at the International Trade Commission. This comes up under the Tariff Act of 1930, and it gives the ITC jurisdiction over products imported into the US. And so it's not a consideration of where the defendant is located or incorporated. You're actually suing over the products. And they have jurisdiction over any case in which some nexus is found between the activities of the respondent and a jurisdictional element of Section 337 of the Act. And so what you're doing in one of those cases, like Phil said, you can't seek damages, but you seek an exclusion order, which is effectively an injunction. You get a ruling that bars the defendant from bringing the product into the US. And so in and of itself, they don't award damages. But if you can prevent, if you're able to prevent a large cell phone manufacturer from importing other cell phones into the US, they would probably turn around and be interested in paying you some money to come to some sort of resolution to let them start selling their products again. And so that would be why you would try to go to the ITC. Like I mentioned before, many jurisdictions have local patent rules. These cover potentially an early disclosure of technical information about the accused products and also sales volumes and revenues. They also could require disclosure of contentions and maybe even a response on infringement and invalidity. And a lot of times they specify certain documents that have to get produced along with that. So, if you have invalidity contentions that say the patent's invalid over certain prior art, you have to produce the prior art. The patent rules often cover claim construction. So they typically dictate a certain time when the parties have to exchange a list of terms they think need to be construed, a time to exchange each party's proposed construction of those terms, and then they specify a format for briefs. An example is that in Delaware, most of the judges like you to do a series of you serve briefs back and forth on each other, and then compile that into one joint brief that only gets filed at the end. And that way the judge has one big document that has all of the arguments in it in a nice, orderly fashion that they can just read straight through rather than having to pull different filings from different places. And the patent rules also sometimes can give you limitations on the number of claims and or invalidity references. That way that, if you go to trial, you're not asserting 75 asserted claims with 400 prior art references. They want you to pare it down to the important issues and maybe, 10 to 15 asserted claims and 15 prior art references. Make you pick the most important ones and not waste the jury's time with anything else. And so based on these factors, we see a lot of, the vast majority of cases are concentrated in a few districts. Right now, that tends to be the Western District of Texas, the District of Delaware, Eastern District of Texas, the Central and the Northern Districts of California, and the Northern District of Illinois. And I've pasted at the bottom some data about how quick some of these jurisdictions are. And I've also included the Southern District of New York there and the District of New Jersey. And you can see that the two Texas courts, based on the orange bars, they get to trial the fastest, whereas Illinois and New York are much slower, by a magnitude of upwards of 2 years slower. Whereas it's not necessarily the same for claim construction. New Jersey and New York seem to get claim construction out very quickly. And often that will be case dispositive. The judge's ruling could dictate whether or not there's infringement or whether or not a prior art reference reads right on the claims. And so many times that can lead to a resolution of the case without it having to go to trial. The defendant also has a little bit of say in the venue. Once a case is filed, a defendant can seek to either dismiss the case for lack of venue entirely or transfer it to a more convenient venue. And there's a series of factors that can get considered. But the gist of it is that a case should be transferred to a different venue if the movement, usually the defendant, demonstrates that the transferee venue is clearly more convenient than the original venue. And that's based on things like where the witnesses are located, where the documents are located, where the parties are actually located as opposed to maybe just incorporated. Just sort of practical considerations like that. So once you've decided where you're going to file, the step one is draft a complaint. As the patent owner, you need to do an investigation before filing to make sure you have a good faith basis to file. You've got to make sure that your client owns the patent. Look at the history of assignments or licenses. And also check to see if the entity that owns the patent is also practicing the patent, either using the method, selling products that meet the limitations, because that can have an impact on damages. And so sometimes it might make sense to have your client transfer ownership of the patent to a different entity to, if that other entity, say a parent-child corporation relationship, if the other one is the one who actually does the selling of the product. You also have to make sure that the patent has not expired, that all the maintenance fees have been paid. You want to look at whether, if your client is practicing the patent, whether they're marking their products properly, because if they're not, then any damages before the complaint become very hard to prove. And then you want to find out who's the infringer and what are their products. You want to do a good analysis of, do those accused products read on the claims? And we often build claim charts where on the one side we put the claim language from the patent and we compare it right next to the product, and we'll draw arrows and circles around different parts of the product and show, this claim limitation is found here and this claim limitation is found there. You also want to look at the amount of potential damages. There's certainly times where there is infringement, but if it's a very small amount, it just may not be worth the cost of suit. And you also want to try and get your experts early. You typically need expert testimony for infringement, for validity, and for damages. And you don't want to leave those to the last minute, because a good expert will help you in discovery to find the information you need to prove your case. And if you miss out on that and wait until after or the very end of discovery to get your experts on board, they might tell you they need certain documents or testimony that it's too late to get. And then you also may want to do some validity searching and either yourself or hire an outside vendor to, search for patents either in the US or elsewhere, search for journal articles, see if there's anything out there that's going to easily invalidate your patent. And it looks like we have our first poll up. So whether or not you need CLE credit, you probably want to click on that. And we'll move to the next slide.
and I just want to chime in here. There are a lot of the steps that we've talked about already when determining whether and where you file a complaint. A lot of these things, looking at issues like patent marking, thinking practically about what the damages are going to be, that should involve a lot of thought beforehand, because it's going to make a big difference down the road. And as Keith mentioned, it really saves you money as a patent owner not to bring a case that's going to result in kind of no injunction and very minimal damages.
Right. As we'll see in a few slides, discovery can get very intense and very expensive very quickly. So you want to do your due diligence ahead of time to make sure this case is going to be worth your while. And here's a couple other steps you want to do. I'll just go through them quickly. If you can, buy the infringing product and actually get your hands on it and tear it apart. You also want to look at the file history of the patent to make sure you haven't, maybe disclaimed some claim scope that's important, or, done anything to hurt the scope of your patent. Like I said, you want to do a claim chart. You want to look at the infringer's patents or any counterclaims they might be able to throw back at you. And then you can prepare your complaint, or you can start with a cease and desist letter if you want. There's pros and cons to each method. And I think that that right there could be a whole CLE hour. So I won't get too far into the weeds. And once you've gotten to that point, if there's still any holes in what you would need to prove at trial, there's certain situations where you can allege the facts in the complaint on information and belief if they're things that you wouldn't necessarily know. Like if you have a decent idea what the defendant's manufacturing steps are, but you can't really know because you can't get into their facility, that's a type of thing where you can plead it on information and belief and then ask for the information in discovery. If you're the accused infringer and a case gets filed against you, or you're aware of your competitor's actions, or you get a cease and desist letter, there's a few things you typically want to do. It's often a good idea to monitor the industry. We have tools where we can get a watch with keywords or party names or technology areas, and we learn about all the patents that get published or issued right away, and we can analyze that and make sure that you're not going to step on a rake. You can also do patent searches if you've got a new product coming out, or a new manufacturing method. It's often a good idea to call up your patent attorney and ask them to do a search for what the prior art is, to make sure you're not just walking right into an infringement case. And then it's also a good idea to monitor what's going on in the patent litigation industry. There's certain areas where there are, shall we say, very litigious plaintiffs who file many, many cases. And that can be often a nuisance and a potentially expensive one. So it's a good idea to just be aware of what's going on there. If you do get sued for patent infringement, typically right away, you want to do sometimes a lot of the same things that a patent owner would do. You look at the patent and the prosecution history. You look for prior art. You get an expert on board and basically figure out what your defenses are. So when it comes time to draft that complaint, there's a couple key things you need to include. Right up front, you list the nature of the action and tell the court and tell the defendant this is a case for patent infringement. You also need to list who the parties are. Identify who the patent owner is, and maybe if there's any licensees involved, identify them. Identify the accused infringer or infringers. Often it might be multiple related entities, and you're not sure who's doing the manufacturing or the importing, that sort of thing. You're also required to list your basis for jurisdiction and venue. You'll typically want to. There's no specific requirements, but list the history of the patent, when it was filed, when it was issued. Describe the accused products, and then you list your counts for patent infringement. You want to put in a claim chart or something equivalent to a claim chart. You're no longer allowed to just say, "Here's my patent, and you infringe it." You have to detail how it is that it's being infringed. And then at the end, you put in your prayer for relief. You ask for damages, an injunction, whatever it is that you're seeking. Most often, these cases are for direct patent infringement. And so that is for anyone who is making, using, selling, or offering to sell a patented invention in the United States, or importing that product into the United States. There's also a statute that covers importing a product that was made elsewhere by a process that is patented in the United States. And then there's also the flip side. There's if you manufacture or obtain components in the US and export them somewhere else into a combination that would read on a US patent, that's an act of infringement. And basically, it's a response to people who try to get around, excuse me, around the US patent law by not assembling their products until it gets outside the country. There's also a specialized procedure for pharmaceutical type cases, where a potential generic company can alert the patent owner that they're looking to manufacture a new drug, and you can, even before they start selling, you can initialize a patent infringement case to basically get a ruling to say whether that generic can or cannot start selling the drug. And then within these, there are some cases of divided infringement where maybe two different companies sort of team up to each do 2 of the 4 steps of the patent. And if there's a sort of concerted action where they're working together, you can sue them both as if they are one and the same. Likewise, there are actions for indirect infringement. The first one is inducement, and that is basically where often this comes from method patents, where, say, a consumer uses a product to perform a method. It's very inefficient to sue every single individual consumer. What you would rather do is sue the manufacturer and seller of that product for inducing those consumers to infringe. And so you have to have the underlying direct infringement by the consumer, and you also have to have affirmative steps by the manufacturer to say, hey, customers, please use my product in this way. There's also contributory infringement, which is selling, 2 of the 4 parts of a device, knowing that they're going to be assembled into an infringing product. The patent owner always bears the burden of proof. It's by the preponderance of the evidence standard, so just more likely than not. And in these indirect patent infringement cases, you also have to prove that the infringer knew of the patent. If they didn't know about it, then it's that's a bar to your suit. There's a handful of major defenses to patent infringement. We've touched on them a little bit already. If there's non-infringement, I don't infringe the patent. There's invalidity, which is basically saying your patent's not valid. The defendant has the burden of proof there by clear and convincing standards, so it's a little bit harder. And you can advance arguments for unpatentable subject matter, such as a law of nature or an abstract idea. You can do lack of novelty or obviousness, which is basically someone else was doing this before, or someone else was doing something very much like it, and it would have been obvious to make that small change. You can advance arguments that the specification is defective in some way, that it doesn't teach someone how to actually do the invention, or it's indefinite. And then there's similar defenses, which are unenforceability, which is a little bit different than invalidity, but effectively the same, such as patent misuse and inequitable conduct, which is essentially a fraud on the patent office in obtaining your patent. And then you could also make a damages defense that say, yeah, I infringe, but, so what? I do it in a way that doesn't actually cause you any harm. A lot of times the defendant will right up front move to dismiss the complaint for one of these bases: a lack of jurisdiction, improper venue, insufficient process or service of process, failure to state a claim, which is basically saying you haven't actually alleged that I infringe your patent. You haven't given me the right details. or failure to join a necessary party. And this is a good tool for a defendant because you can potentially get out of the case right off the bat before you even get into discovery. One of those that I mentioned was the non-patentable subject matter. There was a case in 2014 from the Supreme Court called Alice v. CLS Bank. It sort of modified a little bit the standard for whether something is an abstract idea and therefore non-patentable. Defendants have really seized on that to get out of a lot of cases, and you can see, starting the following year and jumping up big time in 2016, there's been a lot more of these motions to dismiss right at the start of a case based on this, and the success rate varies. You can see, in the chart here, that the green is probably a little bit less than 50%, but if you've got a good argument, I think it's worth a 30 or 40% chance of getting out of the case right off the bat. Plaintiffs can also move for a preliminary injunction. Patent cases typically take 2, 3, 4 years. So if you've got what you feel is a slam dunk case of infringement, you can ask for a preliminary injunction to say, the defendant should not be allowed to sell their product during this case. I would say it's rare that it's granted, but if you can show that somehow you're going to be harmed in a way that damages can't account for, you can potentially file that motion.
Okay. Now I'm going to talk in section 4 about, and we're on slide 21 for those who are following along, the interplay of district court litigation with the PTAB or Patent Trial and Appeal Board proceedings. Many of, depending on the age of the patent, when the patent issued, and several other factors, many of the validity challenges that you can make in the district court can also be brought at the PTAB. For the inter partes review, what you're really looking at is the prior art. So the section 102 anticipation, and section 103 obviousness, where the prior art references, which are the references that came before the, whatever the priority date is, or the really initial time that the inventor brings the filing to the patent office. When you look at that art, which is published patents, articles, things like that, those can be brought in an IPR. The PGR, post-grant review, is more extensive, allows other invalidity aspects, such as the failure of the specification, the lack of enablement, lack of written description, things like that. So why is this important? The fact is that anybody can bring one of these PTAB proceedings, or almost anyone, and you have to do it within a certain amount of time. But if you are sitting there as a defendant and you're facing the unattractive proposition of having to deal with discovery in a district court litigation, you might decide that it is worthwhile to take your chances at the Patent Trial and Appeal Board at the Patent Office, because you get several things. Number one, you're not dependent upon a jury. You're really dependent upon people who have some sort of scientific background, and even more to the point, you're going to have at least one or two of the panelists of a 3-person panel having actual subject matter expertise in the area you're looking at. So if you're sitting there as an alleged infringer, the fact is you're going to have a better audience, most likely, for your arguments, if they are instituted, than you will at the district court, where you're really facing a judge who very often will have a liberal arts degree, and then will be a judicial scholar, a legal scholar, and their clerks, and then the jury who would have to hear this if there are factual issues and it's not a bench trial. So that's part of it. PTAB, it's also because the Patent Office is the entity that issues the patents, they're allowed to basically roll back the clock and say, well, you have to demonstrate in alleged infringer or petitioner in this case, that there's a preponderance that you are right, that you're basically more likely than not, as opposed to invalidity in the district court, which, as Keith said, is clear and convincing evidence. And for anybody who doesn't believe it, those are really meaningful differences. Cases get won and lost in that difference between preponderance and clear and convincing evidence. There is no presumption of validity at the PTAB, which accounts for the standard. And the PTAB is generally cheaper, although I think many people now believe that, it is an expensive sidearm to district court litigation, but because it can stop a litigation in its tracks, including through a stay of proceedings, it has a tremendous amount of value. It is faster, typically, than most jurisdictions. I think the only two jurisdictions who still fail to stay or will not stay cases most of the time are the Eastern and the Western districts of Texas. And we talk about a stay at the bottom, and the fact is that you can, in certain instances, once you have brought your, as a petitioner, brought your petition to the Patent and Trial Appeal Board, you may have the option of going to the district court and requesting a stay, especially if it's a single patent case and the patent and all of the claims asserted are involved in the proceeding. So that is it's really something we talk about with our clients at every case. When you are a defendant and when you are a plaintiff, if you're the patent owner, you prepare for that. You're ready for that challenge, and you really then will investigate ways to stop the proceedings if you can. Turning to the next slide, what the district court stays really is they look at the equitable factors. So this is if you have started a PTAB proceeding, the petitioner and the patent owner may agree and ask the court to stay, and the court may decide on its own not to. But typically they'll agree with something like that if all of the issues that the court has to consider are really moving forward, and that would end the litigation. The question really becomes when you have either multiple patents or multiple claims that are non-patent claims, or different patents that are not against which an IPR or PGR petition is not asserted. Then they'll have to look at other issues. Whether all the asserted claims are involved is a typical factor. Whether all the co-defendants, if there are co-defendants, have joined or will join and be accepting of the results of the PTAB proceeding, whether those claims are instituted or not. If they're instituted, whether they will accept the estoppel that arises as a result of institution, and whether the parties agree that a stay is in the interest of the parties. And a stay is more likely if there's been an institution decision, because that means that proceeding, in all likelihood, has already achieved part of the goal of the statute, which is to get an estoppel that would work against the petitioner to be able to raise any of the defenses that they knew or reasonably should have known at the time of the petition itself. And in other cases like the Hatch-Waxman or the BP-CIA cases, the biosimilars, you're most likely not going to get a stay because the courts really try, and especially for Hatch-Waxman, which has a time-limited automatic stay for the issuance of the grant from the FDA of an ANDA application, so they can't get on the market for 30 months. That's a statutory problem. So what the courts want to do is they want to resolve these generic drug litigations within that 30-month time frame, and that's kind of Congress's nod to all of us. PTAB has the ability to do, we have another poll, so we're at poll number 2. So for CLE credit, check your boxes if you can. My understanding is that hosts and panelists cannot vote. So I'll give you a moment to do that. Hopefully I didn't just click it off so you can't do it. Now that everybody's checked their appropriate box, we're talking more about the interplay with the PTAB proceedings. PTAB also has the possibility of what's called a discretionary denial. So when you bring a petition at the PTAB, there is a possibility that even though you seem to meet the factors for a petition to be instituted, you may have a question that seems like it's ripe for adjudication by the PTAB, that it really goes to validity, that there are questions that can be resolved. The PTAB itself may deny institution of the petition if the district court or the ITC will reach a decision sooner. They're not obligated to wait. The district court's not obligated to wait for the PTAB, and you're governed by what's called the fintive factors. And these really are, it's a PTAB presidential decision, but it really looks at, has the district court action been stayed, or is it likely to be stayed? We look at the trial date versus the PTAB statutory deadline, and this is an area that was very ripe for dispute because there were some trial dates that get set very early in certain districts, including the Eastern District of Texas, Western District as well, where you end up having situations where the trial dates change dramatically, as they move through the case. And so there were situations where it would look like, you're going to trial in 11 months, stay would be issued because of that discretionary denial. Discretionary denial would be issued. The petition would be kicked out and the case would move forward, and then the trial court would then adjudicate 2 years later. So that's one of the issues that you would face. It could be, how much has the district court done? Have we gone all the way through discovery? Have we done claim construction? Are there overlaps of issues? Are there overlaps of the parties, other circumstances, including the merits of the case? And discretionary denials kind of peaked a couple of years ago. There's a lot of activity in legislatures, going to Congress when Congress is operating, which doesn't happen today, but in normal days, or relatively normal days, there's been a lot of activity to try and harness the PTAB and the PTO on issuing things like discretionary denials. So we'll see where that goes in the future. Now, the estoppel that I talked about comes out of Section 315E, but also comes out, I think, 325E, I think, is the one for the PGR. But effectively, what happens if an IPR or PGR results in institution and then in a final written decision, the petitioner and those who are in privity, and that can be a big question mark, may not assert in the district court or the ITC one of these invalidity defenses that, as I mentioned earlier, raised or could have been raised during the, in the petition initially. And so what really happens is, if you bring your petition, you are really foreclosing yourself for later, if you're instituted, from bringing those issues back to the district court. So it's a very strong estoppel. It is really being battled about right now in the district courts. And so the issue is, this could have been raised. Could you have raised it? It's easy to see what has been raised. The question is always going to be, are there other things you could have done at the time? Okay. There is also issues between the two proceedings when we look at protective orders and discovery. And we're going to talk more about discovery. And protective orders generally are issued by courts, but also by the PTAB, to cover confidential information and trade secret information. Usually it relies upon counsel more than anybody else. So the parties are really in charge of doing self-designation, whether something should be or should not be confidential. The parties have the right typically to challenge each other's designation. So the court, if it has to be the referee, it will be. The PTAB has a trial practice guide, and in that it is a default protective order. Some district courts have default protective orders as well that apply if the parties can't agree on something else. But these are important because when you get discovery in the district court, for example, that discovery can be used in the PTAB in certain instances. And if testing and other things are used in the PTAB to justify the petition, you can get discovery on that as well. It's limited, much more limited than the discovery you would get in a district court. And so really you're dealing with issues of a management issue, of having two different fora, of having two different sets of rules that apply, and really challenging yourself at all times as counsel for looking at these, what would the impact be of the words that I use on behalf of my client in the PTAB, and how will that impact what happens in the district court and vice versa. And that's actually true when you have pharmaceutical cases. You also have to think about what are the representations your client is making at the FDA, for example, in order to get either block or otherwise get approval of a drug application, for example. I think we're back to Keith.
Yes, we are. Thanks, Bill. I'm trying to be cognizant of the time, so I'd like to make sure we get through all the topics at least a little bit. The next one is discovery, which unfortunately is the slowest and most time-consuming part of a litigation. So hopefully that doesn't prove true here too. But essentially, discovery is the exchange of information back and forth throughout the case. District courts take a broad interpretation of what is relevant and therefore what is discoverable. You start with initial disclosures, which each party has to list their relevant witnesses, their relevant document sources. The plaintiff has to put forth an initial damages calculation if that's possible. And you have to disclose any insurance that might cover any part of the judgment. There's a few different tools in discovery. There's document requests, there's interrogatories, which are written questions. There's requests to admit, and there are depositions. I would say the document requests and the depositions often take the bulk of the time. You can see many thousands or even tens or hundreds of thousands of documents exchanged in a patent case. It is sort of the bane of our existence, but it is the system in which we live. Once a case is filed, or even before, once you start contemplating it, as the client, you should put a document hold in place. Make sure you preserve any relevant documents and turn off your email auto deletes, because those are potentially useful sources of documents and information, and you don't want to get in trouble for deleting something you should not have deleted. You can also issue subpoenas to get the same types of information out of non-parties to the case, as long as that's not considered harassing or anything like that. As we said, discovery can be very expensive, often the most expensive part of a case, particularly if you get into emails and electronically stored information. There's just, think about how many emails you send every day. They have to be sifted through. Hopefully you can use keywords, and they've got to be reviewed and tagged for responsiveness and privilege and produced or not produced. It can be pretty time consuming. And so the federal rules were changed in, I believe, 2015 to add in a consideration of whether a certain document request or interrogatory is proportional to the needs of the case. Courts have started to be receptive to those kinds of arguments, not as receptive as I'd like them to be. I think they should clamp down a little bit more, but we're at least slowly moving in the right direction. As I said, you can request documents. So that's paper documents, emails. You can even get into text messages if you've got a good reason to. You can request things. You can request samples of the accused products if you have a good reason to. You can ask for an inspection of the defendant's manufacturing facility, for example. Anything that's really relevant to your claims or defenses, you can ask for. There's also interrogatories, so they're written questions. You can seek factual support for your claims or defenses and say, defendant, you've raised this defense. Tell me what facts support that defense. They're often very, very important interrogatories. I'm a big fan of asking them and also pushing the other side for details in response to them. You can ask the other side to identify certain witnesses that are relevant to a particular topic. That way you can take their deposition. Sometimes you can get into some claim construction issues. and there's a duty to supplement these throughout the litigation. And that's particularly important for contention interrogatories, because often by the end of discovery, each side knows a lot more about what their arguments are going to be than at the start. There's requests for admissions, so you can ask for a party to admit a certain fact, and that becomes proof of the fact for the purpose of the case. You can't contest it anymore. In a car accident case, you might say, admit the light was green, or admit there was a crosswalk at this intersection. Sort of basic things like that. You can also use them with documents to just say, admit that this is an actual business record of you. That way you don't have to worry about authentication type issues bogging you down at trial. And then you can take depositions. That's either party witnesses, or you can subpoena non-parties. And that's live testimony as if you were in a court. You get a transcript, and sometimes you can take a video. You can use that at trial, either if the witness is not available, or if maybe it's a third party who you don't want to inconvenience and have to drag them back into the trial. You can just sort of play a snippet of their testimony, or you can use it to cross-examine a witness who is at trial, who maybe says something inconsistent to what they said before. And there's a mechanism called Rule 30b-6, where you can designate certain topics that a corporation has to testify about. And so they have to designate a person to testify who either knows or can investigate the facts regarding those topics. Like Phil touched on, there are confidentiality protections in litigation. We often enter into a protective order right up front that basically says you can designate documents so that they can't be used outside of this litigation. And sometimes you can designate them as, the other party can't even see them, only their attorneys can. And within that, you can enact a prosecution bar to keep the opposing party from considering your technical information in their further patent applications. The next phase of a case is claim construction. It's one of the most important parts of a case. The court has to determine the scope and meaning of the claims of the patent. So essentially, what does your patent cover? Anything that's disputed in the claim terms must be construed by the court. And it's a matter of law for the court and not something that the jury gets to consider. So what does that mean? It's that the claims of determine the scope of a patent, just like the description in a deed does for real property. So it really describes the metes and bounds of what your patent covers. Often in the lead up to that, the court wants a technology tutorial. Judges are often not technical people at all. And if they are technical people, like all of us, they're not technical experts in everything. So you either the parties, or you can use expert witnesses. There's different ways to do it, but you put together a presentation to the judge that just sort of says, this is generally what this case is about. It's about, chemical compounds of this type, or it's about, camera lens manufacturing. And here are kind of some of the general factors that go into that. There's a seminal case from the Federal Circuit called Phillips that guides claim construction. It tells you all the rules. You can review these after the fact. I don't know that I need to read through every single one of them. But basically what it comes down to is, what did that claim term mean to someone in that field at the time of the invention? Like I mentioned earlier, there's a lot of times the court issues rules for the procedure of claim construction. So you exchange the terms that are in dispute, your proposed constructions, you try to meet and confer to limit the ones that are actually disputed to see if you can come to some agreements. Whatever you don't agree on, you put it into a brief, do a big long hearing in front of the judge, and then they typically take it under advisement, and a few months later you get a nice long opinion. There's different ways that the judges will want their briefs handled. Sometimes it's, you file simultaneous briefs. Sometimes you go back and forth. It really goes judge by judge or district by district. And in the end, like I said, in the end, you do a hearing. Usually the judges will give you several hours. And every case that I've been in, the judge pays close attention. They're really invested in this, and they do their best, even if they're not a technology person. And even the judges who clearly don't like patent cases, they're still paying a lot of attention and giving you a lot of time.
Okay, I'm going to try and be quick on this, although these are hugely important topics. Experts. Rule 702 of the Federal Rules of Evidence basically allows anybody who is qualified as an expert by knowledge, skill, or experience, training, or education may testify if there is some issue in which they will be helpful to the trier of fact. And typically what we talk about here is the jury, but it can be a bench trial, so that could be the issue. Typically, there will be expert disclosures that are made ahead of time in case there are objections, conflicts, and things like that. You'll get their prior cases. You'll get a certain types of prior publications. You'll see if they given prior testimony in court. Usually there's an agreement to be bound by the protective order, or maybe a prosecution bar, which relates to a whole different issue that I don't want to go into now. Selecting experts. There are expert witness search firms, but typically we get on we start talking to our clients and others about who are the experts in this area, who would really know the technology, and really a technology known at the time. So that's the importance about some of the experts. There are technical experts. We're really looking, especially in validity issues, but also in claim construction, at the idea of who is this person of ordinary skill in the art. That's the person around whom all of these defenses, all of the infringement contentions usually fall. So what would a person of ordinary skill in the art understand by the claim? What would the person of ordinary skill in the art understand when they're looking at a reference or another reference, whether there's a motivation to combine and things like that? You may have damages experts who are typically an accountant or an economist who has some issue or some background that gives them the ability to kind of look at numbers and understand kind of what the damages might be that are no less than a reasonable royalty. So you have to be able to look at calculations and things like that. And all of that is done from the perspective of assuming liability. Daubert motions, that is a motion to strike or otherwise limit the testimony of a proposed expert, where the testimony, for one reason or another, will not be helpful to the jury. Could be that the expert doesn't have the necessary credentials, that the expert is not really testified to the issue that's at the heart of the proceeding, or that there's a fundamental flaw in the analysis that's performed, or the testing or whatever really isn't performed well, isn't performed properly, isn't duplicable, can't be duplicated. There we go. But effectively, the judge is there to act as the gatekeeper to prevent this kind of testimony from coming in. Now we're at the trial hearing, and really trial is like the ultimate thing for the litigator. We love it. Some people hate it. I love it. I want to be on my feet. I want others on their feet. I want to hear. This is where, you got your Perry Mason moments, but these take weeks, and it's not really as Perry Masonry. We don't do it in a half an hour and are able to have just the very best testimony. The fact is, usually it's in front of a district court. Usually it's in front of a jury. Patent claims are going to have lots of factual issues. You're going to have to teach technology at a level that builds upon itself, so the jury at least can think about and understand the very small issues that are going to determine these things. We impanel the juries using a voir dire. We look at the jury and try and understand who they are. And we're right at the 10 o'clock mark. So I'm just going to finish right here on trial, hearing, and relief, and say basically there are opening statements. That's the way you frame the case, whether you're either side. There's a direct case that's put on by whoever the party actually bringing the case is, but typically it's the patent owner. Then there's going to be a defensive case that is basically the accused infringer. There'll be a charging conference that deals with the jury instructions, and then instructing the jury what to look for. There will be closing arguments, and then there will be jury deliberation and a verdict. There could be damages involved, including reasonable royalty, which is your floor. lost profits, established royalties, convoyed sales as a possibility, and disgorgement of profits in a design patent case. And with all of that, you could still get an injunction, although that's very difficult, and you can pursue willfulness. Now, we have 3 other sections: post-trial papers and appeals. We have some statistics. And the fact is, these are all important things. Take a look at them. They're in the papers in the next 15 slides or so. But you've gotten the meat of it. We'll come back for more. Thank you very much.
Thank you, everyone.